Oh, yes. I was just looking at this First Amendment states in relevant part. Congress shall make no law abridging the freedom of speech. Although this language specifically targets federal Congress, the First Amendment has been held applicable to states by virtue of selective incorporation. Gitlow versus New York of 2010. Most state constitutions have a similar provision protecting freedom of speech, the Illinois Constitution of 2010. Now, I did circle this because freedom of speech has been the focus of countless judicial opinions to summarize U.S. Supreme Court precedent. The word speech has been interpreted to cover virtually any form of expression, including verbal and written words, pictures, photographs, videos, and songs. First Amendment speech also includes expressive conduct such as dressing a certain way. Tinker versus Des Moines Independent School District 2011. Flag burning, Texas versus Johnson 2010, and cross burning, RAV versus St. Paul 2010. Yes. Now, exceptions to the First Amendment protections of free speech. In general, courts have examined the history of the Constitution, the policy supporting freedom of speech, when creating exceptions to its coverage. Yes, Modern decisions afford freedom of speech of the strictest level of scrutiny. Only a compelling government interest can justify an exception. A compelling government interest. Which must use the least restrictive means possible. Sable Commas of California versus FCC 2010. For the purpose of brevity, this book reviews the constitutional exceptions to free speech in statutes criminalizing fighting words, incitement to riot, hate crimes, and obesity. The compelling government interest. Now, when you think about these fighting words, yes, First Amendment, Congress shall make no law. Speech includes verbal, written, pictures, photographs, videos, songs, expressive conduct such as flag burning, so on and so forth. Now, there is exceptions that poses a clear and present danger, and obscenity can be regulated. There's some sort of clear and present danger. I know there is. Yes. See, it prohibits fighting words. Clear and present danger to the public. I'm sure every individual that's ever seen a video of mine felt the clear and present danger to the public that I was inciting some sort of riot or fighting. Those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. Chaplinsky versus New Hampshire 2010. Any criminal statute prohibiting fighting words must be narrowly tailored and focus on imminent rather than a future harm. This imminent harm to the actual society. Yes. I don't know if the United States government has seen the videos that I've been making that were on my 224 YouTube channel. Yes. And fighting words where I was going to sue you, and have you put in prison. Now, a lot of people would say those are really bad words. You can't keep telling oaths of office that you're going to sue them. But every time I documented a lawsuit and I emailed it to those in office, do you consider that a fighting word? Lawsuits. Now, when I give you the actual criminal statutes, the state laws, the RCWs, the procedural due process rules of each and every court of the counties of the state of Washington, and then I go through the treaties, the conventions, the Hague Convention of International Child Abduction. I know it's all fighting words to you in police departments. You're saying, well, he's not going to sue me and take everything I own and have me put in prison for kidnapping. No, he's not. And many fighting word statutes have been deemed unconstitutional under the First Amendment or void for vagueness and overbreadth under the Fifth Amendment and 14th Amendment due process clauses of Lewis versus City of New Orleans, 2010. Now, in the Sheriff's Department, you consider the word lawsuit a fighting word. Ouch! Usually when I make those videos that the YouTube community has found offensive and violating of their guidelines, I just wanted to know how many persons in the Department of Justice have actually gotten a notification from any online website, yes, where you can, gratis, at no cost to yourself, upload YouTube videos. And the Department of Justice looked at each and every individual that has been violating the community guidelines. Now, I know lawsuit is a fighting word for those that are in law enforcement, but I'm really going to sue you. Paul. Now, let's look at the examples of unconstitutional fighting words statute. Yes. Georgia enacted the following criminal statute: any person who shall, without provocation, use to or of another and in his presence opprobrious words or abusive language tending to cause a breach of the peace shall be guilty of a misdemeanor. Georgia Code 26-6303. The Supreme Court determined that this statute was overbroad, void for vagueness, and unconstitutional under the First Amendment, Gooding versus Wilson, 2010. Now, every time I told you to fuck off, pooch, is that a fighting word? As in, you should go home and fuck your wife and you should get the fuck off me. Now, I know. You would say that's unconstitutional of me to say that. The whole thought of it being opprobrious and abusive for me to make videos that suggest to you, the oath, the badge, and the attorney, that not only am I going to sue you for not supporting and defending the Constitution, yes, not only am I going to file criminal complaints against each and every officer in every police department in every city of the United States that has knowledge of this crime, yes, I'm going to tell you to go fuck yourselves. Now, if I was to interpret that in actual language, no. How do you actually do that? Now, the court has held that the dictionary definition, yes, opprobrious and abusive, give them greater reach than fighting words. Thus, the statute is overbroad and does not, see, I put draft right there, yes, does not restrict its prohibition to imminent harm. Now, this imminent harm, pooch, let's say you don't have a penis. Pooch, I tell you to go fuck yourself, and you can't do that. That could be imminent harm to the individuals that are no longer able to masturbate. Ouch! I know. The imminent harm to yourself, yes, that you are not able to release your own orgasm.